Please be seated. New Hampshire Supreme Court is now in session.
This is case 2024-0304, State of New Hampshire versus Adam Montgomery.
Good morning. For the record, Justice Hans Marconi is disqualified in this case. And Attorney Phelan, I understand you reserved 2 minutes for rebuttal.
Yes, I have.
Please proceed.
Good morning. May it please the court, my name is Pamela Phelan, and I am here on behalf of Mr. Montgomery. Today, I'd like to talk about 3 issues. First, the court erred in joining the July 2019 assault charge with the homicide-related charges. Second, the court erred in admitting as intrinsic evidence of other assaults in the weeks prior to the homicide and of blocking communication between HM and her mother. And lastly, these errors were not harmless beyond reasonable doubt. I did raise another issue in my brief, and I'm happy to answer any questions about those, but I'm going to focus on these. The principal concern with these issues is that a defendant be tried on the merits of the charged act and not on propensity and character inferences that may be drawn from evidence of other acts and wrongs. On the first issue, the cases simply should not have been joined for trial. They were not logically and factually connected in a manner that does not solely rely or demonstrate the accused has a propensity to engage in criminal conduct.
Does it make a difference?
Go ahead, Chief.
Does it make a difference that the defendant had joined and the state's assented to motion for joinder in the first instance?
No, I don't. And the reason I don't is because my recollection is that parties agreed to joinder early on in the pendency of the cases, and then as they neared trial, the defense moved to sever them for trial. The state did not contest that the defendant had a right to do that and to have the court look again whether it should be severed.
I guess my question is, if it was in the best interest of justice at the moment the defendant agreed to join the cases, what changed?
What changed is I think through the as defense counsel said, through the development of the case in preparation for trial and additional information that was coming out about how the state was intending to present its case. And the defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are Zwicker letters part of the record? Because I looked at the motion after it references the Zwicker letters, but I didn't see them in the appendix.
No, they are not. But defense counsel talked about what was in them and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was perceiving the state's theory of the case going into trial, that this was going to be a trial about demonstrating a pattern of abuse. And that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial. And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly which witnesses were involved in those.
What's the significance of the 2 different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what...
In terms of this analysis, does the state of mind of the 2 different criminal acts have any bearing on our analysis for joinder?
I don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice. I think the concern when you join those 2 cases together in this case is that you have evidence of the July assault, which, as you note, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of Kayla Montgomery, and she had significant credibility problems. So to the extent that evidence came in through the joinder of these two cases for trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the defense's calculus with respect to the best interest of justice prong of the analysis, but that when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined? In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder, and so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness, or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as the cases got towards the trial date, it was clear to the defense, as they made clear to the trial court, that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
I don't know if, I think over a year earlier is when the cases had gotten joined and started towards trial. I don't know at that point whether there was any written agreement or stipulation about evidence, or whether it was tied to the admissibility of other evidence in the case. And the other issue that I want to address this morning has to do with that ruling about some of the evidence the court determined was intrinsic. I don't think that was there was any agreement that tied the intrinsic evidence issue to the joinder issue.
So the admission of but you would agree, I assume, that the admission of this intrinsic evidence, assaults and abuse and neglect that occurred in the weeks before the murder, that affected the admission of this assault in July, that it made it compounded.
Correct. Yes. I mean, I think both issues are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at the joinder issue, to your point, the prejudice is not just to his trial on the homicide charge, it's also potentially to the trial on the assault charge, because as you point out, the intrinsic evidence came in as intrinsic to the homicide charges. And certainly it was there in the case for the jury to use in assessing both charges, the assault charge and the homicide charge.
So I want to give you an opportunity to address harmless error, but why don't you proceed with your second argument?
Yes. So with respect to the intrinsic evidence issue, there were two pieces of evidence that I focused on in my brief, and I believe it was error. They were not intrinsic to the homicide-related charges, which is what the trial court found. It was the assaults in the weeks leading up to the homicide, and then the bar of communication. With respect to the assaults, the state, even on appeal, says that those assaults, prior assaults, were necessary and essential to proving reckless intent on the homicide. That simply isn't the case. If you look at the state's evidence on the homicide charge, it's the evidence demonstrated, and the state argued that it demonstrated, that Mr. Montgomery acted recklessly by repeatedly punching HM until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
Doesn't it show the extreme indifference?
I think the charge itself shows extreme indifference. The evidence on the charged act, if you believe Kayla's testimony, that in and of itself is more than sufficient to establish recklessness. And I will also point out that this was not a mental state defense on the homicide charge. This was a defense that Mr. Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent on the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for intent, that's 404B evidence, subject to a 404B analysis. That's not an explanation for it being intrinsic to the charge.
Wasn't as the trial court noted, wasn't the jury entitled to some context about events leading up to December 7th?
I don't know why. I mean, context has to be tied to the actual the charged act. I don't know, and I guess this is a question for the state, but what about their evidence and proof on the homicide it has a hole or a gap in it that is impossible for a jury to understand and reasonably assess without having these prior assaults.
To Justice Donovan's point, your yellow light is on.
Yes.
And if you want to get to harmless error.
I do want to get to harmless error. I think that, as I mentioned before, the homicide-related charges rested exclusively on Kayla Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her trial testimony. She only gave that story after she had been arrested, jailed, and was facing additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened, and by the time she got to testify in this case, she was serving a prison sentence on perjury. She had significant credibility problems. The admission of all of this other evidence, either through the joinder of the July assault and the prior act evidence leading up to the the homicide, all of that rested on other evidence. And it gave the jury a reason to, even if they likely had substantial doubt about what Kayla said happened on December 7th, they could fill in that doubt by relying on the improper admission of the July assault evidence as well as the prior evidence leading up to the homicide.
Thank you, Attorney Phelan. You've reserved 2 minutes. Attorney Gagne?
Good morning, Your Honors. May it please the Court, Sam Gagne for the State of New Hampshire. Your Honors, the trial court committed no error when it denied the defendant's motion to sever, when it admitted intrinsic evidence, or when it admitted the body cam video. But even if it were to be assumed that the trial court did commit an error, any such error was harmless beyond a reasonable doubt, given the nature of the errors alleged in this appeal and the overwhelming strength of the state's case, which consisted of eyewitness testimony, numerous witnesses who corroborated that eyewitness testimony, and a mountain of physical evidence, the summit of which held only one conclusion, and the jury reached it.
Do you agree with the defense that the murder conviction rested predominantly on Kayla Montgomery's testimony?
Not necessarily, Your Honor. Certainly her testimony played a large part. She was the eyewitness to what happened on December 7th, 2019. There was no specific evidence to corroborate exactly what happened in that car as far as eyewitness testimony, but to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with the blood in the ceiling of the fit shelter, Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went to investigate and cut out that part of the ceiling, it was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the post-homicide actions of the defendant.
Sure, Your Honor. My ultimate point here is that all of these pieces of corroborating evidence of Kayla saying he hid her in the ceiling, he put her in the freezer at Portland Pie Company, he used a U-Haul to drive her and dispose of her body, he used lime to break her body down. If all of those things could be corroborated by physical evidence to show that Kayla wasn't lying about those things, it becomes a lot easier to credit her testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from raining blows on her face. That becomes a lot easier to buy once the rest of her testimony is credited, and very, very much of her testimony was. Again, through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing, and then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m., and he crossed back over going northbound at 5:25 a.m. The records show that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth, repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again. And that's even before we get to consciousness of guilt evidence of the defendant himself. He tells somebody on a jail call that the efforts to find Harmony's body is just a waste of taxpayer money. One could draw an inference from that yeah, I dumped that in a place you're not going to find it. Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls himself a close friend of his that he hated Harmony to his very core because Harmony reminded him of Crystal. That makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for the Superior Court's decision to allow the pre-December 7th abuse and neglect of Harmony in was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description. Do you recall?
So what I recall, Your Honor, is in closing, in final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence or the July 2019 assault.
I do not recall that, Your Honor.
I didn't see it.
I do not recall that from the record. Speaking of, to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court recognized, wait a minute, my decision on joinder is somewhat implicated here. These are joined charges, and if the evidence of abuse and neglect starts to reach back into September, August, God forbid, July, these cases might start to bleed together. So if the joinder order is to remain sustainable, a sustainable exercise of discretion, the court had to separate those enough such that the jury would be able to evaluate them intelligently and separately, and the trial court did that by limiting it as it did.
Can you respond to the defense argument that none of the evidence and that with respect to the 2 weeks prior to December 7th is material to the crime charge?
Yes, Your Honor. First, I note that Attorney Phelan mentioned she did not understand why any of that was important. I think the easiest way to respond to that before getting into the more substantive reasons is, as this court says time and time again in intrinsic evidence cases, events don't happen in a vacuum. This murder did not happen in a vacuum. The whole story is not told by simply recounting the event of December 7th, 2019. If that's all that is told, all you get is that in a vacuum. I'm not saying this would have been the defense or it could have flown, but you can start to maybe try to create the story that what happened there is actually a loving father, but he was under unimaginable circumstances, homeless, drug addiction, his children living in his car, no steady employment. He was under so much stress and he just snapped in the most unimaginable way. That becomes a much harder argument to even start making if you don't let this story be told in a vacuum, if you get the context. 3 weeks leading up to Harmony's death showed that the defendant did have extreme indifference to the value of her life. He did not treat her the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience, and that evidence showed that. Beyond that, as I kind of just wrapped up, it completed the story, and it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story, because, again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible? What's the relevance of the Manchester Police's encounter with Mr. Montgomery 2 years after the murder?
So that does continue to tell the entire story of the case, Your Honor, because that is it's really the beginning of the story from the law enforcement perspective. That's how the investigation starts. That's the first interaction that law enforcement has with the defendant. It is relevant that when this is reported to the police, What they know is that Harmony is missing, and they say, okay, let's find the defendant because he has custody of Harmony. And it's relevant for the jury to know when the police located the defendant looking for Harmony, where was he? Who was he with? Harmony wasn't there. That's certainly relevant. There is relevance to that. Now, I'm not going to say that the probative value is through the roof on the body cam video, but it was relevant. And the reason it was properly admitted is because the risk of unfair prejudice did not substantially outweigh even small probative value. I contend that it was more than minimal probative value, but even if that's what it was, the risk of unfair prejudice did not substantially outweigh that. The prejudice that the defendant has set forth both in the trial court and in this court is really a tenuous risk of prejudice that is based on mere conjecture and speculation. This video had no audio. The defendant could not be heard. At defendant's brief, page 41, the defendant says the video shows the defendant seemingly answering questions. In that circumstance, and the defendant argues that the risk of prejudice is that the jury is going to infer somehow that he was not cooperative with police or that his right to remain silent was implicated. But the fact that there's no audio, he's shown answering questions, and that defendants carry into trial a presumption of innocence, there was no rational basis to speculate that the jury would take that video and just imply from it that the defendant was being not cooperative with police in that moment while they were just looking for Harmony.
Was there any objection to the testimony about that encounter, separate and apart from the video?
I don't want to say definitively, Your Honor, but I don't believe that there was as I stand here, but my recollection of that is not good enough to answer definitively. Looking quickly to the severance charges, the severance issue, the state notes that, as Justice McDonald pointed out, that the defendant initially moved to join these charges and assented to a motion, and later had a change of heart, which he was entitled to do. The state notes that the case summary, which I don't know is part of the record, but the state could supplement if the court wished for it, seems to show an appearance of another defense counsel between the joinder and the motion to sever. And all of this is really to say that it seems odd that defense counsel at one point in time could have reached this conclusion reasonably and then changed their mind and perhaps reached a different reasonable conclusion, but then argues that the court clearly was unreasonable and untenable in reaching the same conclusion that they had reached earlier. Now, Justice McDonald also asked what changed. As the state argued in the trial court, as far as substantive information, nothing changed. What changed was that some of the stuff is now coming from Kayla. That, it's lost on me, as Justice Gould pointed out, how that could impact the relatedness factors. Perhaps it speaks somewhat to the interest of justice issues, but it does not speak to the relatedness factors. Secondly, the July 2019 assault evidence, it's a little bit difficult to game this out because it's sort of hypothetical, but if these charges were severed, it's certainly possible, if not likely, that the July 2019 evidence could come into the murder trial under Rule 404B. Depending on what the defense and what the state of the facts were, the theories could have been modus operandi, lack of mistake, habit of the defendant in the way he disciplined the child, Harmony, common plan or scheme. There's a number of theories that may have come in under anyway. The trial court may have been cognizant of that and thought that was another reason not to try the case twice. But even getting to the Brown factors themselves, the trial court's order is manifestly reasonable. If you go through the 5 factors, the state conceded and the court found there was no temporal and spatial relationship, so that pebble goes on the defendant's scale. The commonality of the victim and the defendant can't be disputed here. That clearly goes on the state's scale. The similarity in the mode of operation. In July 2019, the defendant gets angry at Harmony and he punches her in the face. On December 7, 2019, he gets angry at Harmony and punches her again in the head. I see my red light is on, Your Honor, and so we would would ask the courts to affirm the trial court's orders and rest on our papers. Thank you.
Thank you very much, Attorney Gagne. Attorney Phelan, you have 2 minutes.
Thank you. With time, I will cover 3 points. Regarding the corroborating evidence, Justice Gould, the state answered your question and talked about substantial, in their view, substantial corroborating evidence. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct. And Mr. Montgomery at trial did not contest the charges and agreed to the charges of falsifying physical evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reasons herself and credibility problems to not be telling the truth about what happened. Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, to tell the whole story. This court has been very clear, whether it's talking about intrinsic evidence or 404B evidence, that those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity purpose. Evidence has to come in for context when it's necessary and essential to proving the charged act. The events leading up to December 7 in those prior weeks were not essential and necessary under the test this court has applied for considering whether it's intrinsic evidence.
Why isn't it relevant to whether the defendant snapped on December 7th?
Well, that wasn't the defense at trial. And until and unless the defense opens the door to that kind of evidence under that theory, it's not admissible. And as we know, as the trial played out, the defense was not that this was a lack of intent. The defense was he didn't do it. Thank you.
Thank you very much, counsel. Case is submitted. Court recess.
All rise.